So you bought your house in Denver and then you discovered a nightmare. Let's talk about what happens next. Today we have Kyle England with us from Spaeth and Doyle. Thanks for being here, Kyle.
Thank you so much for having me.
Yeah, and before we get started, I should say that if you like this real estate content, then please subscribe. All right, let's kick this off. So, let's start with a fact or fiction. Fact or fiction: buyers can sue a seller after closing.
That's a fact.
Mm-hmm.
Yep.
Just for anything, or what for?
Tons of different stuff. Like, I think we talked in our earlier episode, it's non-disclosure is usually like something to do with like it happening afterwards, or like there's a bunch of different like things that can happen where there would be a lawsuit between a buyer and a seller after the completion of the deal. Most of it has to do with some part of the structural or other value of the property that wasn't properly disclosed by the seller that the buyer now wants to recoup some of their money or try to undo the deal.
Well, and interestingly, maybe it would also be super helpful to say, what are some things that a buyer might discover after closing that they cannot come back to the seller for? Do you have a few examples of things like that? Like where people call you and you're like, nah.
If it's in the seller property disclosure, right? Like, and it's something that you've accepted already. If you went and you decided that you were going to purchase a property in as is condition, like, you're giving up quite a bit of like a potential like possibilities that are out there. You do have to file a lawsuit for if there is a boundary dispute that like was known by the seller at the time. You can sue for that. But if it's something that was disclosed or could have been disclosed on a survey, it's not something that's covered in a title insurance policy.
Okay. And then say more about this as is thing, because in my mind, it seems like there's a piece of the contract that says that you're buying it as is. And so aren't they all as is?
There are different levels of like disclosures and representations and warranties, both in the ownership and in the structural, like, the seller's property disclosure, like you are disclosing like, to an extent, the condition of the property and then making representations about certain things about it. And so there are aspects of it that are as is purchases with regards to the real estate contract. But then there are other types of like more investor purchases where they're just saying like, yeah, we know that there may be problems with the property and we still don't care. And a lot of times you can get a better price on a property if you're willing to purchase it in as is condition or forego an inspection. And so if you agreed to that, then you find that there's like a problem. Obviously, you've waived your ability, no matter like how bad the problem potentially is. And so it has to do with the inspection period and the inspection resolutions and all that different stuff. If you're waiving all of that stuff, then we would consider that a straight as is purchase.
Okay, so what kinds of issues might a buyer find that would lead to a lawsuit after closing? Because I know, we're talking about things that weren't disclosed, but can you just kind of tick off like what kinds of things might not be disclosed that a buyer would be like, hey, wait a minute, they should have told us this?
Yeah. So the most like not common example, but the one we always talk about is methamphetamine production, right? So if there was any methamphetamine production and the seller, had any sort of knowledge about it and didn't disclose it, that would be obviously a big one that you would be able to like sue for damages and potentially undo the transaction for.
Wow, I cannot believe that I was not expecting that answer, because in my mind, I think of the meth houses as a very small percentage of what's happening in the world, but you're saying that like that's kind of common.
I wouldn't say common, but just from like my practice in there, I thought like, I was like, there's like how many people have, and it's like, you go to do like meth testing potentially in some of these houses, and like if it's shown that it's on there, and then you have to decide like, okay, can we prove that the seller had like knowledge that this potentially was going on? And if you're able to, like, that's one of the things that our law firm has handled, that there was like a non-disclosure of a methamphetamine production that we were able to show the seller had actual knowledge of. And they were able to get quite a bit of like the remediation costs of the property, which I don't know if you've ever had to deal with a meth remediation, but basically it's down to studs, right? You have to, and sometimes it's even like removing, like it seeps into everything. And so that's why it's such a big thing, is because basically destroys the interior of the house.
Well, and that makes me think about water issues too, which can lead to mold. And that kind of stuff, is something that I think it would be fairly easy for there to be a water issue and mold growing, and the seller might not even necessarily know about it if it's happening like behind the walls, right? So, I mean, do you think that that's one of the biggest issues to suing a seller after closing is like, how do you prove that they knew that?
So through the discovery process, you can subpoena people's emails. You can subpoena like communications between the real estate agent and and the seller. And sometimes you get lucky and you have an email that's like, hey, like we did mold testing like 2 years ago. We found it was in here, and like word, we didn't do anything about it. Like, and so sometimes you get lucky like that, but you do, proving the knowledge component of it is like difficult. Or if you can see that somebody had health issues like the seller did that were associated with it beforehand, that could be like constructive knowledge that they knew that there was mold in there.
What should buyers do if they find that if they close on the house, they find that there's an issue? Like, what is your recommendation for what they should do next?
It obviously depends on the issue. And then step one is look in your inspection, right? Like, was this thing already found? And then you guys just decided, because sometimes like the issue pops up and you like forget about what was in the inspection report and what you were willing to move forward with the deal with. And if it's in there, like you were found it, you didn't go through an inspection resolution, like it's a pretty difficult thing to sue on that particular issue. If you do find something and it's like substantial in the enjoyment of the house or in the like the value, or if there's going to be substantial costs with regards to fixing the problem, then you have to do a cost benefit analysis of like, does it make sense to spend the time, money, and resources to go down the legal route? Because then there's no guarantee of success. Or like, is it substantial enough and you believe that you're going to have a good enough case that you do go forward with it because the recouping of the costs and the damages are going to be worth it?
So, what would you say? Where is that tipping point? Do you, off the top of your head, are you able to say like, if you're if you're planning on suing a seller, you could plan for a range of X amount of dollars to come out of pocket to go down that path?
I mean, any sort of like civil litigation in Colorado, like if you're gonna have to actually like go through a substantial portion of it, you're probably looking at between 25 to like $30,000.
Ooh, okay. So if you're in your house, you have a problem and you're thinking about suing, then the recommendation would be like it's only worth doing it if you think that what it takes to remedy the situation is going to be 30,000 plus dollars.
A lot of the times, unless there's like a very clear route to recovery. New builds are one thing where there's like warranties and stuff that are associated with it. To help protect yourself, you can do a home warranty, like when you purchase your property, if you think that there's potentially going to be stuff at issue, and that can kind of help like hedge your risks of stuff. But if you're going to have to go through like full-fledged, because not only are you going to have to pay potentially a lawyer, but you're going to have to probably hire experts who are going to tie the defect in the house or the damage in the house to like something that the seller did or seller should have known about. And then you're going to have to, if that person can, or you might have to get another expert who may potentially have to like opine as to like what the value of the damages is going to be. So you're like, okay, now we have two expert witnesses. Each one of those bills at between $600 and $1,500 an hour, depending upon like what type of expert that you need.
And is that something that your lawyer would find experts for you, or can you just like hire someone? Like I have a great team of people around me, right? Like so if my client was involved in something like this, could I say, "Oh, I've got a great HVAC guy. He really knows his stuff." Or is that something that you guys find experts for that kind of thing?
It depends on what we need their testimony for. So if it's just like straight value, like of like it having to happen, then you can use a local like HVAC person. But if you're having to get like a structural engineer that is going to tie like some sort of damage to a particular like time period, that's something that usually an attorney would find. But a common person can absolutely get like just Google like Colorado expert witness structural engineer, right? And if you wanted to talk to somebody about it, like you absolutely can. it's always like a cost benefit analysis. And what I always tell people at the beginning is like, okay, there's a problem. Like, what is it going to take to fix? And then if you had a good relationship like with the seller prior to the transaction, the first shot like usually is just seeing like if they will help work with you on something. If they like if you go out to them and you're like, hey, like there's this big problem, there are people that are out there that are like that want to do the right thing. And so you don't want to like scare those people off at the beginning. So the first thing should is usually like a friendly like reach out to be like, hey, we have this huge problem in this house you just sold us. Is there anything that you can do to potentially help us? Like if they were a contractor, that's, a lot of people are doing like fix and flips now. So if that person's a contractor, maybe they're willing to do it for you to just fix it so that they don't, the reputation continues to be good. And so most people want to like go in guns blazing right away. And I'm always like, don't do that because you're going to burn a bridge that potentially you could have used to make this a lot easier.
Interesting. I wanted to circle back too on something that you said earlier about looking for emails or text messages, regarding the disclosure stuff. So, if after the fact you're trying to find out if a seller or their agent knew about something, is that what you would be considered like a fishing expedition, right? Like, and I don't know. I mean, I've heard that term used, and I don't know exactly how that goes in the legal world. But like, is there what has to be in place for you to go subpoena all the emails and text messages and stuff? Like, do you have to have something there to go do that? Versus it just being like, no, you're just on a fishing expedition. You don't have any right to come in and ask for those things yet.
Yeah, so it's always right, it's like a balance, right? So you can't just be like, give me all of your stuff, right? You have to have some sort of reasonable belief in your request for discovery. So anything that's relevant in Colorado, like to the case, is technically supposed to be disclosed by each of the parties. That usually results in some materials, but then you have to use like specific requests for stuff and communications between a real estate agent and their client with regards to whether they had actual knowledge of a defect is usually relevant information that like is going to come in court. Or at least it's going to be something that I can subpoena. So you obviously have to be in a civil case. Like I can't just ask for documents. You have to be in an active litigation. It has to be relevant to the case and it has to be reasonable that you're going to find some evidence to be able to support your claim in court in the thing that you're asking for. And then even though I can get the evidence, there's also the separate task of getting it to be admitted in court. And so if you have these email communications between people, yes, like they probably are going to be brought in like under some business record and stuff, but like a lot of the stuff that you get is technically hearsay, right? Because it's statements made by other people outside of court. And so you're going to have to actually subpoena that person to come get deposed. And then you're going to have that person testify at trial about what that stuff is.
Well, and I hear you saying that anything between a seller and their listing agent would be relevant to the case, and so you might subpoena that. But it wouldn't, it seems like it wouldn't be quite as easy to just say, we want all of the seller's emails to see if there's anything in their emails related to this issue.
That would probably be too wide
Yeah.
of a net. Like you could say like any emails that are like relevant to like a contractor or like something that's out there, like it would be a too overarching of a request to say like give me your emails for the last 5 years. Not only would that be overburdensome, but like the reality of our team being able to sort through that many emails would probably not be very good either. And so you have to go in with like you can't just be like, oh, we hope we find something. You have to have like a little bit of a belief by it, or the other side can say no, right? And then you have to go to an evidentiary hearing. You have to prove it. You have to show basically like why it should be disclosed and then why it should be admitted and stuff. And so the more specific of an attorney can get with regards to what they're asking for, the less likely it is a judge will agree with the defense or another party that it's not relevant. And so
Okay.
you have to be like relatively specific.
Well, and so do you have any other advice for sellers to protect themselves other than what we've been saying, which is this disclose, disclose, disclose? Obviously, you should say anything that you know of, but what other tips do you have for sellers?
That's a good question. Make sure like you understand the contract the things that are like that you're representing, if you're doing any sort of representations and warranties like about the house, that you understand exactly what those things mean. If you look at the inspection that is going to be done by the buyer in that particular, like, make sure you get a copy of that, right, so that you can look at it yourself and understand like what was found like with the property. And if there's stuff that you're not going to have to do an inspection resolution about, just like note those things so that you know that they were actually found and that the buyer agreed that they were going to take the property in that condition.
Oh, that is interesting because as a listing agent, I never want the buyer's inspection report.
Interesting. Okay.
Like they can submit their inspection objection items. And if the buyer's agent just sends me the report and I have not requested it, I might look at the report just for the things that they've objected to, but I am not looking at the rest of that report. And if I don't have to look at it, I won't even open it or save it. And I would never pass it along to my seller. Um, just because, I mean, inspectors they're all doing their job. They're all professionals. They're all human, right?
Right.
So all of the reports are going to be different just depending on who does it. But I don't know. I just don't think that I'm doing my seller a good job for my seller by presenting them this big laundry list document of every tiny thing that's wrong with the home. And then, because then you have to expect them to disclose all of that. Right? And so, like, now what are they doing? Now they have to pull up the buyer's inspection report and update their seller's property disclosure? I don't know. And maybe I shouldn't be saying any of this on camera right now. What are your thoughts on this?
I like look at it from a perspective of like having a good idea of like what the condition of the property was, but you're right, like it could potentially create these additional complications. And so I don't know if there's like, I think the disclosure part, like that we've already talked about, is like the most important part. And then thinking about if it would be important for these particular like people to have a copy of the buyer's inspection report, like it could be, or like you're saying, maybe it does create more complications. And so it's probably situation specific on like whether you think it might be helpful to your party or not.
Yeah, kind of up to your professional.
Yeah, right.
Which having professionals, I mean, that's another thing that the seller could do. And keeping documentation too. I mean, this is something that in both of our jobs is a huge, huge thing. Like we're always documenting, keeping documentation. In fact, I just downloaded a new thing so I can now PDF all my text messages.
Nice.
Because, I mean, so much, I would say the majority of my business is being done through text messages at this point. But if you're a homeowner, keep your documentation. When you have something done at your house, and you get the invoice, please, like, either stick it in a folder or, scan it and put it in an electronic file. The chances that eventually you're going to sell the house, like, some people stay in the house until they pass away, but I think a lot of homeowners end up being sellers at some point, and they should be keeping this documentation. And it just never surprises me, or I guess I should say, it always surprises me at the amount of documentation that homeowners don't have.
Yeah, if you have like worked on your house, but structurally, like any of the foundational stuff, like any of like what all of that different stuff is like really important to save. And like I'm not the best with paper either, so like if I get anything important, it's getting scanned in, so I have an electronic copy of it.
So, I guess the last question that I have on this whole topic of, a buyer finds a problem with their house and they go back and, potentially sue the seller afterwards. What kinds of misconceptions do consumers have about these types of lawsuits?
That's a really good question. Um, the Just because unfortunately you find a defect in the house after the closing transaction happens, that doesn't necessarily mean you have a case against somebody. And that's a bummer to have to tell people, is like, yeah, I know, that sucks that like this thing isn't working, or like you're gonna have to continue to put a little bit more like work into this house, but whether it is actionable but you're not going to be able to recover or not, or whether it's just not actionable, is like a reality that people like have to sort of understand. And so going in, there's everyone wants to walk into houses with like a turnkey, like outlook on the property. And to the, you can do that to extent with a lot of cosmetic stuff, but just understanding that within the first couple years, there probably is going to be some stuff that like has to be repaired on a house because that's just the way that houses are.
You're so right. I think that's such great advice, just to homeowners and buyers in general. Is like, first of all, no house is perfect, even new builds. No house is perfect. And once you get in, you are the caretaker of that home and that property. And there's always something. There will always be something. And this is why, like, you know, you won't find me to be a person who's like, "Oh, everybody should buy property," because in some ways, yes, but in other ways, there are definitely reasons not to buy property. Um, and that responsibility of caretaking a property is one of them. Like, if you are not able and you can't afford to hire help, like you otherwise you're just going to be living in a place that eventually ends up falling down around your ears, because it has to be taken care of.
All homes, unfortunately, need work all the time. It's one of the joys of home ownership.
So I kind of want to end the episode, but I have one more question that I wanted to circle back with you on. You mentioned something about mitigating risk with a home warranty. And I was surprised to hear you say that because as we're talking about lawsuits and we're saying like, you're going to spend 20 to 30,000 on litigation, so don't bother if the issue is not larger than that to fix. And in my mind, I think of home warranties as like they might come fix your furnace or they might come fix your washer, dryer, or appliances. And none of that stuff, like, I don't know that home warranties cover anything structural or mold or like some of the things that would end up being like a real high ticket fix. But I'm just curious, like, where you're coming from on that.
Yeah, so like HVAC stuff is like what I was like kind of having in mind to the extent that you can, because HVAC, like, depending upon like how the home warranty is like worded, right? Like you could be talking about like an AC unit, or like you can be talking about, oh man, like if there really is like a problem, like you're talking about knocking out drywall and stuff like that, and like that sort of like thing that can be encompassed in it. But you're right, like mold remediation not going to be something that's covered by a home warranty. Usually like structural or foundational stuff is not going to be, but the larger systems that are at play, like, swamp coolers, like potentially can be covered by them, the HVAC stuff. I had one where like the home warranty covered a boiler, and like that was like a sort of expensive fix, which I've never even seen a boiler in a house before. And there's like so many valves and stuff. And so the bigger ticket, like appliance type items that are not necessarily right structural or anything like that. But that's what I had more in mind is you're like, the mitigating like part of it, like is trying to understand that those systems may, especially if they're a little bit dated in like the properties, or if like the seller was good enough to put new things into the property and they're transferring you the actual warranty of it, and just making sure that those things are transferred to you correctly.
Oh, yeah, that's a good little tidbit there. All right. Well, I think we've exhausted this topic about you bought a house, you have a problem, like should you sue, should you not sue? So thanks so much for going through all of that with us today, Kyle.
Yeah, absolutely.
If you like this content and want to support the channel, don't forget to hit the like, subscribe, and alert bells before you go.